Question 1. Topic: cross-examination. While investigating a complicated issue between different parties, a defense attorney is cross-examining the prosecution's key eyewitness in a high-profile criminal trial. The witness initially provided clear account of the defendant's alleged involvement but has made slightly inconsistent statements during the trial. The defense attorney aims to use impeachment techniques to weaken the credibility of the witness. The following strategies would be the most effective under these circumstances. They ask open-ended questions to allow the witness to clarify their testimony in their own words. B. Use leading questions that highlight the inconsistencies in the witness's prior statements. C. Challenge the witness by accusing them of lying outright, regardless of available evidence. D. Introduce a new piece of exculpatory evidence that contradicts the witness's testimony. Answer: B. Use leading questions that highlight the inconsistencies in the witness's prior statements. Explanation: cross-examination serves to challenge the credibility of a witness by exposing inconsistencies, bias, or unreliable testimony. Leading questions, those that suggest the answer, are a critical tool in cross-examination because they allow the attorney to maintain control and highlight discrepancies. The Federal Rules of Evidence 3-600 allow attorneys to impeach witnesses using prior inconsistent statements. A. Incorrect. Open-ended questions are more appropriate for direct examination as they allow the witness to freely narrate events. However, during cross-examination, open-ended questions give the witness an opportunity to rehabilitate their testimony rather than expose contradictions. B. Correct. By structuring questions to focus on prior inconsistencies, the attorney can systematically discredit the witness's reliability, making their testimony less persuasive. C. Incorrect. Accusing witness of lying outright is risky and may backfire, as it could be seen as argumentative rather than fact-based. The attorney should let the jury infer dishonesty based on the inconsistencies revealed. D. Incorrect. Introducing new evidence at this stage may not be procedurally allowed unless it is properly authenticated and admitted. The focus of cross-examination should be on exposing weaknesses in the existing testimony rather than introducing new evidence. Mastering cross-examination requires strategic questioning to subtly undermine witnesses' credibility while maintaining courtroom decorum. Question 2. Topic: rules of evidence. Hearsay exceptions. In high-stakes environment where multiple challenges arise, prosecutor attempts to introduce piece of testimony from witness who claims that now deceased individual had identified the defendant as the perpetrator of violent crime. The defense objects on the grounds of hearsay. The prosecutor argues that the testimony falls under an exception to the hearsay rule. Which of the following except would most likely apply in this case? A. Present sense impression. B. Dying declaration. C. Statement against interest. D. Business records exception. Answer: B. Dying declaration. Explanation: under 3-802, hearsay is generally inadmissible, but there are exceptions. A dying declaration 3-804b2 is one of the well-established exceptions that allow otherwise inadmissible hearsay evidence if the declarant is unavailable, e.g. deceased. The statement was made under the belief of impending death. The statement concerns the cause or circumstances of death. The case is homicide or civil case, not other types of criminal cases. A. Incorrect. A present sense impression 3-803-1 is a statement describing an event made while perceiving it or immediately thereafter, since the declarant is not narrating an event as it happens but rather reporting past information. This does not apply. B. Correct. A dying declaration applies because the statement concerns the cause of death and was likely made under the belief of impending death. C. Incorrect. A statement against it 3-804b3 applies when the declarant makes a statement that is against their own penal, financial, or legal interests. However, in this case, the statement is about someone else, not the declarant's own wrongdoing. D. Incorrect. The business records exception 3-803-6 applies to records kept in the ordinary course of business, not to personal statements made by individuals. Attorneys must understand these exceptions to effectively argue for or against the admissibility of evidence in trial proceedings. Question 3. Topic: closing arguments. Addressing jury instructions during seamless transition where continuity must be maintained. Defense attorney is delivering closing argument in medical malpractice case. The jury instructions include an explanation of preponderance of the evidence as the burden of proof and negligence. Which of the following strategies is the best approach for the defense to emphasize during closing arguments? A. Argue that the prosecution must prove guilt beyond reasonable doubt. B. Highlight inconsistencies in the plaintiff's expert witness testimony to create doubt about the standard of care. C. Focus solely on the credibility of the defense witnesses without addressing the plaintiff's claims. D. Refuse to engage with jury instructions and instead rely on an emotional appeal to sway the jurors. Case facts, evidentiary weaknesses, and jury instructions to create doubt and persuade jurors that the plaintiff has not met their burden of proof. Question 4. During a major transformation where existing methods must be reevaluated, an attorney is handling a high-profile criminal case where the admissibility of expert testimony is a critical issue. The defense has presented an expert witness whose methodology is novel and not widely accepted in the scientific community. The prosecution objects, arguing that the expert's testimony does not meet the required legal standards for reliability. The judge must decide whether to admit or exclude the expert's testimony. What is the appropriate legal framework for the judge to use in making this determination? A. The Frye Standard, which requires that the expert's methodology be generally accepted within the relevant scientific community. B. The Daubert Standard, which requires that the judge assess the reliability and relevance of the expert's testimony based on a set of factors. C. The Federal Rules of Evidence Rule 403, which excludes evidence if its probative value is substantially outweighed by the risk of unfair prejudice. D. The Best Evidence, which requires that the original document or recording be produced when its contents are in dispute. Answer. B. The Daubert Standard, which requires that the judge assess the reliability and relevance of the expert's testimony based on a set of factors. Explanation. The admissibility of expert testimony in federal court and most states follows the Daubert Standard established in Daubert v. Merrill Dow Pharmaceuticals, Inc. 1993. Under this standard, the judge serves as the gatekeeper and must evaluate the expert's testimony based on 1. Whether the theory or technique has been tested, 2. Whether it has been subjected to peer review, 3. Whether there is known or potential error rate, 4. Whether standards and controls exist, and 5. Whether it has gained general acceptance within the scientific community. This ensures that unreliable or speculative testimony does not influence the jury. Frye Standard, Option A, was the previous test which relied solely on general acceptance within the scientific community. However, it was deemed too rigid and was replaced in federal courts by Daubert. Rule 403, Option C, deals with balancing probative value against prejudicial impact, but does not establish the reliability of expert testimony. The Best Evidence Rule, Option D, pertains to documentary evidence, not testimony. Question 5. While managing a hybrid approach where timing issues affect the trial schedule, a defense attorney is in the middle of cross-examining a key witness. The prosecution repeatedly objects on the grounds that the defense is using leading questions. The judge sustains some objections and overrules others. What is the best strategy for the defense attorney to continue an effective cross-examination within legal constraints? A. Avoid all leading questions and instead ask only open-ended questions to ensure fairness. B. Frame questions as statements of fact rather than questions to avoid objections. C. Use leading questions strategically to control the witness but ensure they remain within proper scope. D. Ignore the judge's rulings and continue with the same approach to maintain consistency. Answer: C. Use leading questions strategically to control the witness but ensure they remain within proper scope. Explanation: cross-examination is designed to test the credibility of a witness, challenge inconsistencies, and expose biases. According to the Federal Rules of Evidence 3611C, leading questions are generally permitted during cross-examination because the opposing party's witness is less likely to be cooperative. However, an attorney must use leading questions strategically, ensuring they remain relevant to prior testimony and do not go beyond the scope of direct examination. If judge sustains an objection to a particular line of questioning, the attorney should adapt rather than persist in manner that could be viewed as disrespectful to the court. Option is incorrect because open-ended questions allow the witness more control, which is disadvantageous during cross-examination. Option B is incorrect because attempting to frame statements instead of questions is improper and can be objected to as argumentative. Option D is incorrect because disregarding judge's ruling can lead to sanctions, loss of credibility, or even contempt of court. Question 6. In a multi-location scenario where consistency requirements must be met, a plaintiff's attorney is preparing for jury selection in complex civil trial involving allegations of corporate fraud. The defense is expected to use peremptory challenges to exclude jurors they believe will be sympathetic to the plaintiff. However, the plaintiff's attorney suspects that the defense's use of peremptory challenges is based on racial discrimination. What argument can the plaintiff's attorney make to challenge the defense's jury selection strategy? A. File Batson challenge, requiring the defense to provide race-neutral explanation for their jury strikes. B. Request an immediate mistrial on the grounds of systemic discrimination in jury selection. C. Move for directed verdict, arguing that an unfair jury pool prevents fair trial. D. Invoke the work product doctrine to obtain the defense's internal jury selection notes. Answer: 8. File a Batson challenge, requiring the defense to provide a race-neutral explanation for their jury strikes. Explanation: the U.S. Supreme Court case Batson v. Kentucky 1986 established that peremptory challenges based on race violate the Equal Protection Clause of the 14th Amendment. If a party suspects that the opposing counsel is using peremptory challenges discriminatorily, they can raise a Batson challenge, shifting the burden to the other party to provide a legitimate, non-discriminatory reason for the jury strikes. Question 7. During a seamless transition where continuity must be maintained, an attorney representing a defendant in a criminal trial is making an objection to the prosecution's use of witnesses' prior inconsistent statement. The prosecution argues that the statement is admissible for impeachment purposes. What key legal principles determine whether the statement can be admitted into evidence? A. The statement is admissible only if it was made under oath at previous proceeding. B. The statement is inadmissible unless the witness acknowledges its inaccuracy. C. The statement is admissible for impeachment, but not for proving the truth of the matter asserted. D. The statement is inadmissible under the Confrontation Clause unless the witness consents to its introduction. Answer: C. The statement is admissible for impeachment, but not for proving the truth of the matter asserted. Explanation: under the Federal Rules of Evidence 3613, prior inconsistent statements can be used to impeach a witness's credibility but are not admissible as substantive evidence unless they meet hearsay exception G. 3801 D1A. If the statement was not made under oath in prior proceeding, cannot be used to prove the truth of the matter asserted but can still be used to challenge the witness's reliability. Option is incorrect because prior inconsistent statements made under oath at prior hearing can be admitted as substantive evidence, but they are not the only statements admissible for impeachment. Option B is incorrect because the witness's acknowledgement is not required for impeachment. Option D is incorrect because the Confrontation Clause, 6th Amendment, protects defendants' right to cross-examine witnesses but does not prevent prior inconsistent statements from being used for impeachment. Question 8. During a major transformation where existing methods must be reevaluated, a corporate attorney is advising a multinational company on compliance with the Foreign Corrupt Practices Act (FCPA). The company is expanding into new markets, and some employees have suggested providing facilitation payments to foreign officials to expedite routine governmental actions such as customs clearance. What legal risks should the company consider before proceeding with such payments? A. Facilitation payments are illegal under the FEPA and could result in criminal penalties. B. Facilitation payments are generally exempt from FEPA prohibitions but may violate local foreign laws. C. The company can safely make facilitation payments as long as they are disclosed in financial reports. D. The FCPA does not apply to non-U.S. subsidiaries, so only the parent company would be at risk. Answer: B. Facilitation payments are generally exempt from FEPA prohibitions but may violate local foreign laws. Explanation: the Foreign Corrupt Practices Act (FEPA) prohibits U.S. companies and individuals from bribing foreign officials to obtain or retain business. However, facilitation payments, small payments to foreign officials to expedite routine governmental actions, e.g., visa processing permits, are not considered bribes under the FEPA and are technically exempt from prosecution under U.S. law. However, this does not mean the payments are risk-free. Many foreign countries have strict anti-bribery laws that do not recognize the facilitation payments exception. For example, under the UK Bribery Act, facilitation payments are illegal. Option is incorrect because the FEPA does not outright ban facilitation payments. Option C is incorrect because disclosing the payments does not make them legal. Option D is incorrect because the FEPA applies to U.S. companies and their subsidiaries worldwide. Question 9. While managing a hybrid approach where timing issues affect the trial schedule, a civil attorney is negotiating a settlement in a high-stakes breach of contract dispute. The plaintiff has agreed to an initial settlement amount, but the defendant's counsel introduces last-minute confidentiality clause restricting public disclosure of the terms. The plaintiff's attorney is concerned that this may violate public policy. Under what circumstances might confidentiality clause be unenforceable in settlement agreement? A. Confidentiality clauses are always enforceable in private settlement agreements. B. Confidentiality clauses are generally enforceable but may be struck down if they conceal wrongdoing of public concern. C. Confidentiality clauses are only enforceable if both parties explicitly waive their right to public disclosure. D. Confidentiality clauses are unenforceable if the settlement agreement is related to civil matter rather than a Answer: B. Confidentiality clauses are generally enforceable but may be struck down if they conceal wrongdoing of public concern. Explanation: confidentiality clauses are commonly included in settlement agreements to prevent parties from disclosing terms. However, courts may refuse to enforce them if they violate public policy, such as when they conceal evidence of sexual harassment or discrimination claims, e.g. #MeToo, corporate fraud or violations of securities laws, public health and safety concerns. For example, in whistleblower cases or regulatory investigations, a court may rule that confidentiality cannot override the public's right to know about corporate misconduct. Option is incorrect because courts may void confidentiality clauses that suppress public interest concerns. Option C is incorrect because explicit waiver does not override legal concerns. Option D is incorrect because enforceability is not based on whether case is civil or criminal. Question 10. In a multi-location scenario where consistency requirements must be met, a class action lawsuit is filed against a pharmaceutical company for failing to disclose severe side effects of a widely used drug. The company argues that individual plaintiffs should file separate claims instead of proceeding as a class. What factors will the court consider when determining whether to certify the class action? A. Whether the plaintiffs can demonstrate that the company's conduct caused identical harm to all members of the class. B. Whether each plaintiff has unique damages that would make class certification impractical. C. Whether the class representatives adequately represent the interests of all class members. D. Both and C. Answer: D. Both and C. Explanation: a court will certify a class action under Federal Rule of Civil Procedure 23 if numerosity. The class is so large that individual lawsuits would be impractical. Commonality. There are common legal factual questions. Typicality. The lead plaintiff's claims are typical of the class. Adequacy. The lead plaintiffs and attorneys can fairly represent all class members. Courts often deny class certification if damages are too individualized or if plaintiffs cannot prove that the company's misconduct affected all class members in similar way. Option alone is incomplete, as typicality alone is not enough. Option B is incorrect because class actions can still be certified even if damages vary as long as liability is common. Option C alone is insufficient as commonality is also required. Answer A. Under GDR, the company must notify regulators of the breach within 72 hours, while under the CPA, affected customers must be notified without undue delay. Explanation. The General Data Protection Regulation (GDPR) applies to any company processing the personal data here, e.g. citizens, regardless of location. Under Article 33 of DD, a company must notify its Data Protection Authority (DPA) within 72 hours of discovering a data breach. Failure to comply can result in fines up to 4% of annual global revenue or €20 million. The California Consumer Privacy Act (CPA) requires companies to notify affected consumers in the most expedient time possible following breach. Unlike the GDPR, it does not specify an exact time frame but emphasizes timeliness. Option B is incorrect because neither GDPR nor EPA mandates automatic compensation. Fines and lawsuits depend on negligence. Option C is incorrect because DDR applies to any company handling EU citizens' data. Option D is incorrect because notification is required regardless of whether financial harm is proven. Question 12. While maintaining a delicate balance between competing priorities, a labor attorney is advising a multinational corporation on implementing an employee monitoring system to track productivity. Employees are concerned about privacy violations. What legal considerations must the company evaluate before proceeding with electronic monitoring in the workplace? A. The company can freely monitor employees since it owns the equipment used at work. B. The company must inform employees of monitoring policies and ensure compliance with applicable labor and privacy laws. C. Employees have an absolute right to privacy and workplace monitoring is prohibited. D. The company must seek explicit employee consent before any form of workplace monitoring. Answer. B. The company must inform employees of monitoring policies and ensure compliance with applicable labor and privacy laws. Explanation. Workplace monitoring laws vary by jurisdiction but generally require employers to clearly communicate monitoring policies to employees, comply with federal and state privacy laws, e.g. Electronic Communications Privacy Act in the U.S., limit monitoring to legitimate business purposes, e.g. productivity tracking. Securities and jurisdictions like the European Union and DDR require explicit consent for certain types of employee monitoring, but in the U.S., consent is often implied if employees are informed. Option is incorrect because ownership of equipment does not eliminate employees' privacy rights. Option C is incorrect because workplace monitoring is legal if conducted properly. Option D is incorrect because explicit consent is not always required in jurisdictions like the U.S. Question 13. As part of a rapidly evolving legal landscape, a technology startup is developing an artificial intelligence (AI) system for hiring decisions. The system evaluates candidates based on resumes and video interviews. Civil rights advocates raise concerns about potential discrimination. What legal risks should the company consider under anti-discrimination laws? A. Hiring systems are exempt from anti-discrimination laws because they do not involve human decision-making. B. The company must ensure that its AI system complies with Title I of the Civil Rights Act by avoiding bias based on race, gender, and other protected characteristics. C. If bias is unintentional, the company is not liable for discrimination. D. The company can avoid legal risks by keeping AI decision completely confidential. Answer. B. The company must ensure that its AI system complies with Title I of the Civil Rights Act by avoiding bias based on race, gender, and other protected characteristics. Explanation. Title Roman of the Civil Rights Act prohibits employment discrimination based on race, color, religion, sex, or national origin. AI systems must be audited for algorithmic bias to ensure compliance. The Equal Employment Opportunity Commission (EOC) has warned that AI-based hiring systems can perpetuate bias if they reflect historical hiring disparities. Option is incorrect because AI systems used in employment decisions are subject to anti-discrimination laws. Option C is incorrect because unintentional bias still violates Title Omen under the disparate impact doctrine. Option D is incorrect because transparency is required for legal compliance and fairness audits. Question 14. Amidst an unprecedented regulatory shift that demands adaptability, a financial institution is restructuring its lending policies to comply with the Truth in Lending Act (TILA). What are the key requirements for lenders under TILA? A. Lenders must provide borrowers with clear and accurate disclosure of loan terms, including APA and repayment schedule. B. Lenders are not required to disclose interest rates if borrowers agree to the loan terms. C. TILA only applies to mortgages, not credit cards or auto loans. D. Lenders can change loan terms after the agreement is signed as long as they notify borrowers within 30 days. Answer. A. Lenders must provide borrowers with clear and accurate disclosure of loan terms, including APA and repayment schedule. Explanation. The Truth in Lending Act (TILA) requires lenders to disclose key credit terms to consumers, ensuring informed decision-making. Key disclosures include annual percentage rate, APA, total loan costs, payment schedules, and penalties. Option B is incorrect because disclosure of interest rates is mandatory. Option C is incorrect because TILA applies to various types of credit, including mortgages, auto loans, and credit cards. Option D is incorrect because lenders cannot change loan terms unilaterally after agreement. Question 15. When managing a complex case involving multiple stakeholders, a legal advisor is assisting a company in navigating an antitrust investigation. Regulators suspect that the company engaged in price fixing with competitors. What legal principles govern price fixing under antitrust law? A. Price fixing agreements among competitors are illegal under the Sherman Antitrust Act. B. Price fixing is only illegal if it results in consumer harm. C. Companies can avoid liability by making informal agreements rather than written contracts. D. Price fixing is legal if it helps stabilize market prices. Answer. A. Price fixing agreements among competitors are illegal under the Sherman Antitrust Act. Explanation. The Sherman Antitrust Act prohibits agreements between competitors to fix prices, limit production, or divide markets. Price fixing is considered illegal, meaning it is automatically unlawful regardless of intent or market impact. Option B is incorrect because consumer harm is not required to prove a price fixing violation. Option C is incorrect because informal agreements, e.g., verbal collusion, are still illegal. Option D is incorrect because stabilizing prices does not justify anti-competitive conduct. Question 16. When confronted with an intricate legal dilemma requiring careful analysis, an intellectual property lawyer is advising a startup on protecting its new software technology. The company is considering patenting its algorithm but is unsure whether software patents are legally enforceable. What are the key legal considerations regarding software patents in the United States? A. Software can be patented if it meets the requirements of novelty, non-obviousness, and usefulness. B. All software is automatically patentable since it is a unique creation. C. Software patents are only granted if the code itself is completely original. D. Software is never eligible for patent protection under U.S. law. Answer. A. Software can be patented if it meets the requirements of novelty, non-obviousness, and usefulness. Explanation. In the United States, software patents are granted under specific conditions. The U.S. Patent and Trademark Office also requires that an invention be novel, non-obvious, and useful. The Supreme Court case Alice Corp. CLS Bank 2014 ruled that abstract ideas like mathematical formulas cannot be patented, but software that provides a specific technical solution may be eligible. Option B is incorrect because not all software qualifies, only those that meet patentability criteria. Option C is incorrect because originality of code is not the sole factor. Functionality is key. Option D is incorrect because software patents exist, but they require compliance with legal standards. Question 17. As the legal landscape undergoes a fundamental transformation, a corporate governance expert is advising a board of directors on fiduciary duties. What are the primary fiduciary duties that corporate directors owe to their company and shareholders? A. Duty of care, duty of loyalty, and duty of obedience. B. Duty to maximize short-term profits for shareholders. C. Duty to follow all employee demands. D. Duty to avoid taking risks in business decisions. Answer: A. Duty of care, duty of loyalty, and duty of obedience. Explanation: duty of care. Directors must make informed, well-reasoned decisions and exercise due diligence in company matters. Duty of loyalty. Directors must act in the company's best interests, avoiding conflicts of interest or self-dealing. Duty of obedience. Directors must ensure compliance with laws and corporate policies. Option B is incorrect because directors must consider long-term sustainability and not just short-term gains. Option C is incorrect because directors are not obligated to follow all employee demands. Option D is incorrect because reasonable risk-taking is part of sound business judgment. Question 18. Amidst the increasing complexity of cross-border transactions, a multinational corporation is assessing the risks of violating the Foreign Corrupt Practices Act (FCPA). What are the key provisions of the FCPA and how do they impact business practices? A. The FCPA prohibits U.S. companies from bribing foreign officials to obtain business advantages. B. The FCPA applies only to criminal cases, not civil penalties. C. The FCPA only applies to companies physically operating within the U.S. D. The FCPA allows small grease payments to expedite routine government actions. Answer: A. The FCPA prohibits U.S. companies from bribing foreign officials to obtain business advantages. Explanation: the Foreign Corrupt Practices Act (FCPA) applies to U.S. companies and individuals worldwide and prohibits bribery of foreign officials. It covers both direct and indirect payments e.g. through third parties. Option B is incorrect because the FCPA includes both criminal and civil penalties. Option C is incorrect because U.S. companies operating abroad are still subject to the FCPA. The option D is incorrect because while the FCPA allows facilitation payments, their use is highly scrutinized. Question 19. While maintaining a delicate balance between competing priorities, a human resources manager is drafting a workplace discrimination policy. What key legal principles should the policy address under U.S. employment law? A. Employers must prevent discrimination based on race, gender, religion, age, disability, and other protected characteristics. B. Employers can make hiring decisions based on gender and age if it benefits company culture. C. Workplace discrimination laws apply only to government employers, not private companies. D. Discrimination is only illegal if it is intentional. Answer: A. Employers must prevent discrimination based on race, gender, religion, age, disability, and other protected characteristics. Explanation: Title Roman of the Civil Rights Act prohibits workplace discrimination based on race, color, religion, sex, or national origin. The Americans with Disabilities Act (ADA) protects against disability discrimination. The Age Discrimination in Employment Act (ADIA) protects workers over 4 years old. Option B is incorrect because hiring based on gender or age is illegal unless there is a bona fide occupational qualification. BOC. Option C is incorrect because anti-discrimination laws apply to both public and private employers. Option D is incorrect because disparate impact claims can arise from unintentional discrimination. Question 20. Amidst an unprecedented regulatory shift that demands adaptability, a financial institution is reviewing its compliance with anti-money laundering (AML) laws. What are the key components of an effective AML compliance program? A. Customer due diligence, transaction monitoring, and suspicious activity reporting. B. Allowing anonymous transactions to protect customer privacy. C. Monitoring only high-value transactions above $1 million. D. Keeping compliance policies informal to avoid unnecessary costs. Answer: A. Customer due diligence, transaction monitoring, and suspicious activity reporting. Explanation: Customer due diligence (CDD). Financial institutions must verify customer identities and assess risk. Transaction monitoring identifies suspicious patterns e.g. structuring deposits to avoid reporting thresholds. Suspicious activity reporting (SAR). Banks must report suspicious transactions to regulators. Option B is incorrect because anonymous transactions increase fraud risk. Option C is incorrect because AML laws apply regardless of transaction size. Option D is incorrect because compliance must be formalized and documented. Question 21. In a high-stakes environment where multiple challenges must be addressed simultaneously, an attorney is preparing to cross-examine a hostile expert witness in a high-profile securities fraud case. The expert has presented financial projections that support the defense's claim of non-fraudulent intent. What is the most effective cross-examination strategy to discredit the expert's testimony? A. Ask broad and general questions to make the expert contradict their earlier statements. B. Rely on technical jargon to confuse the expert and make them appear uncertain. C. Use leading questions to highlight inconsistencies between the expert's current opinion and prior statements or published works. D. Focus on discrediting the opposing attorney rather than the expert witness. Answer. C. Use leading questions to highlight inconsistencies between the expert's current opinion and prior statements or published works. Explanation. The Federal Rules of Evidence 3613 allow attorneys to impeach witnesses by showing prior inconsistent statements. Cross-examination should be controlled, strategic, and precise, using leading questions to challenge the expert's credibility. A prepared attorney will compare the courtroom testimony to prior depositions, articles, or reports they authored. Option is incorrect because broad, general questions provide the witness with too much room to maneuver and explain their position without contradiction. Option B is incorrect because using technical jargon to confuse the expert is not an ethical or effective approach. Skilled expert can clarify terms, negating the strategy. Option D is incorrect because attacking the opposing attorney instead of the expert weakens the credibility of the cross-examiner and is unlikely to influence the court. Question 22. During a comprehensive review of a process that needs improvement, a law firm's litigation team is assessing the strengths and weaknesses of potential negligence lawsuit. Which of the following is the most crucial element to establish liability? A. Proving that the defendant had duty of care toward the plaintiff. B. Showing that the plaintiff suffered emotional distress. C. Demonstrating that the defendant's actions were intentional. D. Establishing that the plaintiff did not contribute in any way to the harm suffered. Answer A. Proving that the defendant had a duty of care toward the plaintiff. Explanation. Negligence claims require 4 essential elements. Duty of care. The defendant owed duty of care to the plaintiff. Breach of duty. The defendant failed to meet that standard of care. Causation. The breach directly caused the plaintiff's injury. Damages. The plaintiff suffered actual harm. Option B is incorrect because emotional distress alone is insufficient without proving duty, breach, causation, and damages. Option C is incorrect because negligence does not require intent. It focuses on failure to meet reasonable standard of care. Option D is incorrect because contributory negligence varies by jurisdiction. Some states allow partial fault under comparative negligence laws. Question 23. While analyzing the root causes of sequential problems in legal advocacy, a prosecutor must decide whether to introduce prior bad acts evidence in a criminal trial. Under the Federal Rules of Evidence, when is such evidence admissible? A. To show the defendant has a bad character and is likely guilty. B. Only if the defendant has already been convicted of similar conduct. C. When it is relevant to proving motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake. D. Under no circumstances because it is always considered prejudicial. Answer C. When it is relevant to proving motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake. Explanation. 3404b governs the admissibility of prior bad acts evidence. While character evidence is generally inadmissible to prove conduct, it can be used to show motive, e.g. financial crimes to cover debts, opportunity, e.g. prior experience with a security system used in burglary, intent, e.g. prior similar fraudulent schemes, plan or identity, G. Using the same unique method in multiple crimes. Option is incorrect because character evidence cannot be used solely to show propensity. Option B is incorrect because prior acts do not need to result in convictions to be admissible. Option D is incorrect because such evidence is admissible under specific circumstances, even if prejudicial. Question 24. During an emergency response where multiple areas are impacted, a trial attorney representing a corporation in a class action lawsuit must decide whether to file a motion in limine before trial. The motion seeks to exclude certain evidence that the opposing counsel plans to introduce regarding prior corporate misconduct. What is the primary legal standard a judge will use to determine whether to grant the motion? A. The evidence must be excluded if it has any prejudicial effect on the jury. B. The evidence must be excluded if it is more prejudicial than probative under Rule 403 of the Federal Rules of Evidence. C. The evidence must be excluded only if it is hearsay with no exceptions. D. The evidence must be excluded if the opposing counsel has not disclosed it during discovery. Answer: B. The evidence must be excluded if it is more prejudicial than probative under Rule 403 of the Federal Rules of Evidence. Explanation: a motion in limine is a pretrial motion requesting the court to exclude certain evidence before trial. Under Rule 403 of the Federal Rules of Evidence, courts weigh the probative value of evidence against its prejudicial effect. If the unfair prejudice, confusion, or potential for misleading the jury outweighs its usefulness, the court may grant the motion to exclude the evidence. Option is incorrect because evidence with any prejudicial effect is not automatically excluded, only when it substantially outweighs probative value. Option C is incorrect because hearsay can sometimes be admissible under exceptions 3801, 805. Option D is incorrect because undisclosed evidence may be excluded due to discovery violations, but this is separate from motion in limine ruling. Question 25. In a situation where formal requirements conflict with practical considerations, a defense attorney is strategizing how to argue for a directed verdict in a criminal trial. The prosecution has presented circumstantial evidence but has failed to provide direct proof of intent beyond a reasonable doubt. Under what conditions should the judge grant the motion? A. If the prosecution has failed to present any evidence, direct or circumstantial, supporting the elements of the crime. B. If the defense believes the prosecution's case is weak, even though some evidence supports the charge. C. If the jury appears unconvinced by the prosecution's arguments. D. If the defense has provided stronger case than the prosecution. Answer A. If the prosecution has failed to present any evidence, direct or circumstantial, supporting the elements of the crime. Explanation: a motion for a directed verdict, also called judgment of acquittal under Rule 29 of the Federal Rules of Criminal Procedure, asks the court to enter a verdict in favor of the defendant before the case goes to the jury. This is granted only if the prosecution has failed to present legally sufficient evidence for each element of the crime charged. Option B is incorrect because a weak case does not justify a directed verdict. Some evidence, even circumstantial, can be enough for the jury to decide. Option C is incorrect because the jury's perception of the case is not legal basis for granting directed verdict. Option D is incorrect because having stronger defense does not automatically mean the prosecution has failed to meet its burden. Question 26. While analyzing the root causes of sequential problems in trial advocacy, a plaintiff's attorney must determine whether to object to line of questioning that calls for hearsay testimony. Which of the following scenarios would qualify as inadmissible hearsay? A. Witness testifies about what they personally observed at the scene of crime. B. Doctor testifies about patient's medical condition based on the patient's statements made for medical diagnosis or treatment. C. Business owner testifies about financial record but has no first-hand knowledge of how it was created. D. Police officer testifies about what victim told them at the scene regarding the identity of the perpetrator. Answer D. A police officer testifies about what a victim told them at the scene regarding the identity of the perpetrator. Explanation: under Rule 801C of the Federal Rules of Evidence, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. The statement made by the victim is an out-of-court assertion introduced by the officer, making it hearsay unless an exception applies. Option is incorrect because first-hand observations are not hearsay. They are direct testimony. Option B is incorrect because statements made for medical diagnosis or treatment fall under the free 803(4) exception to hearsay. Option C is incorrect because business records may be admissible under free 803(6) business records exception if authenticated. Question 27. In a high-stakes environment where multiple challenges must be addressed simultaneously, a trial attorney representing a corporate defendant in a product liability case is preparing for a critical cross-examination of an expert witness. Which of the following is the most effective strategy to undermine the expert's credibility? A. Questioning the expert's credentials and past professional experience. B. Highlighting prior inconsistent statements made by the expert in depositions. C. Arguing that the expert's testimony is based on speculative assumptions. D. Demonstrating that the expert has been compensated significantly for testimony. Answer: B. Highlighting prior inconsistent statements made by the expert in depositions. Explanation: cross-examination is A critical trial advocacy skill in impeachment through prior inconsistent statements is one of the most effective ways to undermine an expert witness's credibility. The Federal Rules of Evidence 3613 specifically allow for witness to be confronted with inconsistencies in prior testimony, making it difficult to maintain credibility before the jury. Option: questioning credentials may weaken credibility but is less effective if the expert has solid qualifications. Option C, arguing speculative assumptions, is important but is better suited for Daubert challenge rather than direct impeachment. Option D, highlighting compensation can show bias but does not necessarily discredit testimony if compensation is typical for expert witnesses. Thus, exposing prior inconsistent statements directly challenges the expert's reliability and can sway the jury's perception. Question 20. During a comprehensive review of a process that needs improvement, a litigator notices that jurors struggle to understand complex forensic evidence in medical malpractice cases. Which method would be most effective in ensuring that the jury correctly interprets this evidence? A. Simplifying the medical testimony by eliminating technical details. B. Using demonstrative exhibits such as charts, models, or videos. C. Relying on cross-examination to expose flaws in the opposing expert's testimony. D. Encouraging jurors to rely on their personal experiences to interpret medical facts. Answer: B. Using demonstrative exhibits such as charts, models, or videos. Explanation: jurors often struggle with technical or scientific evidence, making demonstrative evidence crucial. Under Federal Rule of Evidence 1006, visual aids like charts, models, and videos help distill complex information into understandable terms. Option while eliminating technical details could misrepresent crucial facts, leading to an incomplete understanding. Option C, relying on cross-examination, is useful but does not directly aid the jury's comprehension. Option D, relying on personal experiences, is risky because it can introduce juror bias, violating due process. Thus, using demonstrative evidence ensures clarity while preserving the accuracy of the testimony. Question 29. When implementing new protocols in a shared environment, a law firm must adapt to new electronic discovery rules that require stricter compliance with data preservation. Which of the following steps should be prioritized to prevent spoliation claims? A. Immediately instructing all employees to delete outdated or irrelevant electronic files. B. Establishing a litigation hold policy and notifying relevant personnel to preserve data. C. Relying on opposing counsel to request specific documents before taking action. D. Destroying only the emails and digital records not directly related to ongoing cases. Answer: B. Establishing a litigation hold policy and notifying relevant personnel to preserve data. Explanation: spoliation of evidence, the destruction or alteration of relevant data, can lead to severe legal consequences, including adverse inference, instructions, or sanctions under Federal Rule of Civil Procedure 37E. To prevent this, litigation holds must be implemented as soon as litigation is anticipated. Option: deleting outdated files could unintentionally destroy relevant evidence, violating discovery obligations. Option C: waiting for opposing counsel is risky since duty to preserve evidence exists before request is made. Option D: destroying non-related records is problematic since the firm may not initially know which records will become relevant. Thus, the best practice is to implement litigation hold immediately, ensuring all potential evidence is preserved. Question 30. In a scenario where efficiency decreases across multiple departments due to legal compliance changes, a corporation is considering the adoption of an alternative dispute resolution ADA clause in its standard contracts. Which of the following would provide the greatest balance between legal protection and efficiency? A. Mandating binding arbitration for all disputes, regardless of type. B. Allowing either party to choose mediation or arbitration based on the nature of the dispute. C. Eliminating litigation options entirely and requiring all disputes to go through private mediation. D. Implementing a tiered dispute resolution clause with negotiation, mediation, and arbitration steps. Answer: D. Implementing a tiered dispute resolution clause with negotiation, mediation, and arbitration steps. Explanation: a tiered dispute resolution clause ensures that low-cost cooperative methods like negotiation and mediation are attempted before binding arbitration, providing efficiency while maintaining legal safeguards. This approach is commonly used in complex commercial contracts. Option Q's mandatory arbitration can be efficient but may be too rigid, eliminating the chance for amicable settlements. Option B, choosing mediation or arbitration provides flexibility but lacks structure, which can lead to delays. Option C, private mediation only may fail if parties do not reach an agreement, forcing them into costly litigation anyway. By prioritizing negotiation and mediation first, a tiered approach offers a cost-effective and legally sound balance.